topic on company meetings. This is also a topic under the module of company law. By the end of the discussion, you will be able to understand characteristics of company meetings. You'll also be able to explore different kinds of company meetings, and also you will be able to understand matters that are discussed in what we call the annual general meeting. I know that is a famous name, but for this particular discussion, we will now be able to understand exactly what is discussed in that particular meeting. Now we begin by asking ourselves a very, very important question on what is a company meeting. And we are saying a company meeting is simply the coming together of at least a quorum of members in order to transact either ordinary or special business of the company. So there must be people coming together, and the main purpose should be able to transact ordinary or special business. You're going to understand what we mean by those kinds of businesses as we proceed. We're also saying another definition by Sharp versus Davis. This was a case in 1971. It described a company as an assembly of people for a lawful purpose. So as people gather, the key emphasis in our definition number 2, excuse me, is to say that there needs to be a lawful purpose. You need to, whatever is being discussed or whatever matters that are enabling you to gather must be lawful. So you should not gather for illegal activities, illegal discussions. This, of course, is going to vary depending on country to country and what they can call legal or illegal. Now we have what we call the characteristics of a company meeting. We are saying this meeting must have at least 2 or more members present for it to be able to proceed. Another one is only lawful business must be discussed in the meeting. That one we have mentioned. And also the meeting must be held at a particular place, date and time. So there must be a particular place, date and time that the meeting is to be held. And the other one is that the meeting must be held as per the provisions of the rules or the Companies Act. So you must abide to what the Companies Act says in terms of when the meeting should be held, and also it goes ahead and describes the particulars that are supposed to be discussed in that particular meeting. Now there are situations when we can have a one-person meeting. A one-person meeting will happen in situations, for example, when a meeting has been convened by the national government or the central government. They may require one person to convene or represent the rest of the members, company members. The other one, another situation is when an adjourned meeting lacks quorum. So quorum is what we say that it is the minimum number of persons that are supposed to be present in a meeting. So when they are not present, then the meeting can be able to be adjourned. And once they have been adjourned and still there is no quorum, then there is a provision to have a one-person meeting. The other one is a meeting convened by company law board. So the board may convene a meeting, and the other one is a class meeting by shareholders, when one person holds a particular class of shares alone. That is a situation also that would warrant or inform the taking place of one-person meeting. We have different kinds of meetings that would take place in an organization or in a company setup. And these meetings are as follows. We have what we call the statutory meeting. We have what we call the annual general meeting. We have what we call the extraordinary general meeting, and we have what we call class meetings. So we will seek to understand more in terms of these meetings. So after that, we have what we call the meeting of directors. We can have meetings of board of directors, meetings of directors, and also meetings of creditors. And also we have what we call the meeting of shareholders. They are owners of the company, but they do not take part in the management of the meetings or the management of the company. And in these meetings of shareholders, they can be represented by the people that we call directors. Now we begin by understanding what is it that we call a statutory meeting. And we are saying once a company has been authorized to commence business, it must hold a statutory meeting within a period of not less than 1 year or 1 month, and not more than 6 months. So statute, of course, means the law. So it is a requirement of the law, or the Companies Act, that the moment you have been given an opportunity to commence business, once you receive your certificate of incorporation, then you can now be able to hold a statutory meeting. And it should not be not less than 1 month, and it should not be, you should not do it past 6 months. So it is a very strict meeting because it has timelines, and when you do not hold it, there are consequences that might happen, including the registrar of companies preventing you from continuing to commence business. So it is a very, very important kind of a meeting. Then this is a common type of meeting, what we call the annual general meeting. And we are saying shareholders hold this meeting, and it happens once a year. So it is the famous meeting we call the AGM. And we're also saying the main purpose of this kind of a meeting is to review the progress and prospects of the company, and elect its office bearers by the coming year. Yeah, so it's very, very important to have this as the main purpose, or the main purpose. To be able to understand the main purpose, you need to know that it is all about reviewing prospects of the company, and also being able to elect office bearers, auditors, directors, and so on and so forth. Now, what are some of the aspects that are discussed in the annual general meeting? Number one is the adoption of annual accounts, directors' reports, and auditors' reports. Remember, we will have annual accounts reports. Directors will also have their reports. Auditors will also have their reports. So when we gather for annual general meeting, or when shareholders attend the annual general meeting, then it is a platform to be able to receive these reports, and also ascertain and approve them as the true copies of the reports. And also it is an opportunity to discuss a few affairs, or the affairs that are in that kind of a report, or the reports that we have just highlighted here. Another routine business of the annual general meeting is to declare the dividends. I have said dividends are the payments someone receives because they are shareholders in a particular company. And the other one is to elect the directors in place of those retiring. So it is an opportunity in the annual general meeting to do elections. And the other one is to appoint auditors and fix their remuneration. So all these are activities that are very, very important when it comes to the annual general meeting, and they would form part of the agenda of the meeting, or the annual general meeting. We have another kind of meeting we call the extraordinary meeting. We are saying this is a meeting that is held between two general meetings. There are situations where we have already done our annual general meeting. Remember, we are calling it annual because it is done once. But there are situations where an issue might arise that cannot be able to wait for the next annual general meeting. So if that issue is a serious issue or a burning issue, then we can hold what we call an extraordinary meeting. And we are saying we discuss particular matters of company importance. And I've said those matters of company importance may not be able to wait for the next annual general meeting if we had already held our meeting. So some of the matters that may be discussed in these kind of meetings include specific subjects which cannot be postponed to the next annual general meeting. There are matters that may not be able to wait. And the other one is alteration of a clause in the memorandum of association. Maybe we want to change a particular clause. I believe you remember those clauses from our discussion. We talked about the object clause, we talked about the name clause. Remember, there is also an area we were discussing about their alteration. So maybe we are in a situation that we want to alter our object clause. It is an opportunity to have the extraordinary meeting. The other one is changes in articles of association. So over and over again, the articles of association are going to change, and then we will be forced to make changes through extraordinary meetings. We also have another kind of meeting we call the class meetings, and these are meetings that are held by a certain class of shareholders, and such kind of meetings can be attended only by that class of shareholders. So when we talk about classes of shareholders, we have different classes of shares in companies. So based on the class that you are in, we can have meetings for particular shareholders. And of course, when we meet for that kind of meetings, we seek to be able to maybe alter the rights and privileges of shareholders. So that's very, very important to be able to note and understand. And it's also an important kind of a meeting that might take place. When we talk about different classes of shares, or we can have what we call ordinary shares. We can also have preference shares, management shares, redeemable shares. So it depends with, so we can have a class meeting, for example, for only people that have ordinary shares in the company. Then we also have a meeting that we are saying it is a meeting of the board of directors, and we are saying this is a meeting where most of the powers of the directors are exercised, and it is held as follows: at least once in every 3 months. So we can have that kind of a meeting, and the other one is at least 4 such meetings shall be held in every year. So that is a clarification on the meetings that we are calling the board of directors. The other one is board meeting business, when the board meets to for any discussions. What could be those discussions? The first one is to make calls on shares. The other one is to discuss the transfer of shares, if any. The other one is to discuss wealth investment of the company. The other one is to be able to determine the policies of the company. Maybe we want to have a change in policies. We can have the board meeting maybe to approve the new policies and discuss them also. And finally is to think of any difficulties arise in the company. Any challenges that are arising, they can also be discussed in this particular situation. Then meeting of committee of directors. Now, the directors can also have subcommittees. And these subcommittees are the ones that are forming this particular kind of a meeting. And we are saying certain committees may be formed by the board of directors and delegate some of its powers to them. This kind of committees consist of only directors. So there are some committees of the main directors meeting. And of course, sometimes when we have these committees, they are meant maybe to simplify work and maybe have the subcommittee do some assignment and then report to the main meeting of directors. And this, of course, is authorized by the Articles of Association. It authorizes the delegation of such powers to committees. And finally, on the types of meetings, we have what we call the creditors meetings. We are saying it involves a meeting of people owed money by a company that is bankrupt. And also, in this kind of meeting, also the creditors vote to agree the plan to divide the assets that remain. So they are also very, very crucial kinds of meetings. So I invite you to understand the different types of meetings, and also be able to do also research on them to be able to understand them better for the benefit of understanding the topic and the discussion around company meetings.